cik ir pulkstenis tagad? Ir? 3, jā. Good afternoon, ladies and gentlemen. We are ready to start our second workshop, which will be dedicated to implication of the Brexit on trademark and designs. We will have the opportunity to ask questions online via our YouTube chat channel, and also via hashtag #QuestionECTA on Twitter. So I encourage those who are not able to participate here to ask the questions and follow us via internet. So the speaker of our second workshop is Mr. Philip Harris. Philip is a barrister with St. Philip's Stone Chambers. Before being called to the bar in 2014, he had 30 years' experience as a registered trademark attorney and solicitor advocate in in-house and private practice. He specialized in all aspects of contentious and non-contentious trademark law and has experience of copyright, designs, and other soft IP rights too. Philip's contentious practice include infringement and passing off in the English courts, especially in the Intellectual Property Enterprise Court, where he has the first trademark attorney to appear as a trial advocate. So he also specialized in proceedings before the UK Intellectual Property Office, as well as before EUIPO. A fellow of the Charter Institute of Trademark Attorneys, Phillips first joined its council in 1998 and was the institute president from 2006 until 2008. He is still a council member. He serves on several committees, including the Brexit Task Force, and was recently appointed as the chair of the Education Policy and Development Committee. From 2009 until 2012, Philip was a board member of the Intellectual Property Regulation Board. And today, Philip will tell us about the Brexit, the implication for EU trademark law and design. Philip, the floor is yours, and we are happy to have you here today.
Thank you very much, Ruta, for your kind introduction, for picking me up so much. That's excellent. It is, well, first I should say good afternoon. Labdien, I think is the correct word. Thank you, Auntie Google. I managed to get through that. It's a pleasure to be here in Riga, particularly because this is the third and final Baltic capital that I managed to visit. I've been to the other two, Vilnius and Tallinn, and I must say I love the area and love the people and love the cities that you have. And this seems to be a very nice city, even though it was raining quite heavily when I walked down earlier on. Now, I've been asked today to talk about the implications of Brexit for European Union trademarks and designs. When I came to think about what this talk would look like, how it would be structured, it occurred to me it could simply be 2 slides. The first slide you see there, and the second slide saying, who knows? Because the real problem is we really don't know anything at all about the thinking on how intellectual property rights, and in particular the European trademark system, is going to be affected by Brexit. And from a UK perspective, as you've probably noticed, not only does the debate about the whole issue go on at quite an elevated level, but the position, as we understand government sees it, seems to be changing weekly. Until recently, it was radio silence on everything. And then in the last couple of weeks, various things have started to emerge about how our government is moving towards realising a structure for Brexit. And in particular, that's relevant to intellectual property, of course, we've seen that they have made a decision that they are going to ratify the UPC, notwithstanding that nobody yet knows whether we will continue to be a member of the UPC system after Brexit. But I think it's possible to put a number of interpretations on that, and certainly I don't think government wants anyone to put a particular interpretation on that, but you could see that as a hopeful omen, if nothing else. So, let's move on. Pressing the button, and maybe I've got it the wrong way up. Let's just see what happens. Yes, excellent. Always have the gun pointing away from you, as they say. Well, as you all know, much to the surprise of many, the United Kingdom voted by a not insignificant margin, it must be said, to leave the European Union on the 23rd of June 2016. At the present time, let's not forget that the UK is still a member of the European Union. We haven't left yet. We're still here. We're still fulfilling our role as EU members, and within the profession and its relationship to the European Union trademark and design system, we are still very active and contributing in all the channels of communication discussions that go on. And I mention that because some people seem to be under the impression that things changed immediately. We've certainly seen some communications that imply that, and it's not the case. The UK is still a member, and UK professionals are still carrying out a full role in the European intellectual property system. As yet, Article 50, which is the supposed trigger for us leaving the European Union, hasn't been invoked. Now, some of you may have been following the soap opera in the United Kingdom system, whereby an issue as to who can invoke Article 50 has gone as far as the Supreme Court. In fact, that's being played out even as we speak, and there are some very learned dissertations on both sides about whether or not it's a prerogative measure that basically the Prime Minister, Mrs May, can take on her own, just by signing a piece of paper or a letter, or whether it has to go to Parliament for a vote. I don't know if any of you are familiar with a Norwegian concept called slow TV. Some of you may be, where basically for hours at a time they show on television a particularly slow activity, such as a fire burning or a long train journey, with no commentary, and it runs for hours and hours and hours. I can tell you that watching the Supreme Court deal with the Article 50 case makes that look like a racy programme. It makes it look like Formula One. It's been very slow. But equally, it's showing our justice system, I think, in a very good light, because it has taken a lot of the heat out of the debate in the United Kingdom. So the message that I want to give you as regards the background is that it's business as usual. At the present time, nothing has changed. And UK representatives continue to act for clients in EUTM and design matters. Now, it's fair to say that the Chartered Institute of Trademark Attorneys has been a big champion of the European trademark and design system. We have pushed it, recommended it to clients, going right back to its very inception in the mid-1990s. And so it would be odd if we now said, we don't like that anymore, let's get rid of it. On the contrary, if we could keep it as an institute, we probably would. But we are faced with the situation that we have, which is that it's beginning to look as though keeping it all in its current form is not a reality. What CITMA is keen to do is to make sure that as far as possible, no one's rights are adversely affected. These rights have been paid for, they've been argued over, they've been processed through. There should be, as far as possible, a continuance of the rights that people already have, with as least interference and cost as possible. And certainly CITMA wants to carry out as positive and constructive a role in the forthcoming changes as it can. And to that end, we've been working closely with UKIPO and with the relevant government department, which straight after Mrs May's promotion to Prime Minister was renamed BEAIS. I think that's how you pronounce that. It's a rather strange thing. Responsibility for intellectual property sits within BEAIS. And I know they're talking to... We have all these lovely acronyms for our government departments that are dealing with these things. So the Department for Exiting the European Union is called DEXEU. There's another department, I think the Department of International Trade, DIT. And I know that they are all three are talking together about the various issues that arise. And of course, the other two departments are having to consider a lot more things than just intellectual property. There's a great deal more at stake, and we have to keep these things in perspective. But within a couple of weeks of the decision the referendum decision on leaving the European Union, we were in meetings with the department, with BEAIS, and in particular, I was along with our president, Kate O'Rourke, to meet with the Minister for Intellectual Property, Baroness Neville Rolfe, along with other stakeholders. And I can say that the department and Baroness Neville Rolfe in particular are fully alert to and aware of the complexity of the issues and the importance of the issues. So it's not something that's being ignored. UKIPO 2 is completely alert to all of the issues that are concerned and is working constructively to try and come to resolution within the limits they have of working within government as a whole. Obviously, I don't know what their position on it is. They're not allowed to tell us. But I can say that we do engage with them. And in fact, we were down there just a couple of weeks ago at a forum that they organised to discuss various issues. So the Chartered Institute has got an opportunity to input into the future. And of course, we'll take that as far as we can. We've been leading on two particular areas. Registered rights and what happens to those. And for most people, that's going to be the most important area. How do we deal with all these European rights after we exit the European Union? And also the issue of representation before, in particular, for trademark attorneys, EUIPO. By the way, if I slip back into old terminology and call it OHIM, just put it down to the fact that I'm getting old, all right? You know, I just haven't got over it yet. It's also an issue as regards the Court of Justice of the European Union, because quite apart from the fact that UK trademark attorneys have rights of representation at EUIPO, UK lawyers have rights of representation at the CJEU. And so there's a wider issue about how far they will continue to be able to represent there, if at all. And as well as working with government, we have been working closely with other key stakeholders in other areas, for example, the Law Society, the Bar, and the various IP federated bodies that are concerned with these issues. So, what do we know already? At the risk of stating the obvious, we do know that we are definitely leaving the European Union. Now, you might think that is obvious from the fact we had a referendum result, but it isn't until it becomes government policy. And when Mrs. May was promoted to the role of Prime Minister, she said, yes, we are definitely leaving. So we know that is currently government policy. That's what's going to happen. We also know that the intention is that the UK will not be subject to the decisions of the Court of Justice of the European Union after we leave. Now, in the context of trying to keep as much as possible of the European trademark system, that has obvious implications because the appeal route is to the Court of Justice of the European Union and its decisions currently bind the UK. So you might almost think that the perfect solution of keeping what we have isn't possible. But who knows? A long time to go yet. We do know that the government is seeking the best possible deal it can for trade. And within that, of course, IP rights will feature very heavily. So we'll be trying to get something that's beneficial to UK businesses and which encourages foreign businesses to want to trade with the United Kingdom. So it's not in its interest to make it a difficult system, you would think. We do know that government intends our country to continue to be partners with Europe after we leave. Notwithstanding the tone of the debate sometimes at the moment between the EU and the UK, the fact is they intend, as we understand it, everybody intends to get along just fine afterwards, depending on the relationship that is put together. Of course, that will depend on how the negotiations pan out and, to some extent, the strength or weakness of the stance taken by everybody concerned. We'll have to wait and see. Timing, it now seems increasingly certain, particularly in the light of developments this week, that Article 50, one way or another, will be triggered, as Ms May has said, by the end of March 2017. And that means 2 years. To March 2019 is when we expect to leave the European Union, subject, of course, to any transitional provisions. And that date's quite interesting, isn't it, in terms of the European Trademark Directive, which, as I recall, the transposition date for that is in January 2019. We'll come back to that in a minute. And we do know that the UK is going to ratify the UPC. In fact, there was an announcement made last Monday. Like I say, if you're an optimist like me, you'd take that as a good omen. But really, you can't really read much more into it than in the government statement. It's something they feel it's appropriate to do at this time. What happens afterwards, whether we stay a member of the UPC, has yet to be decided, if in fact it's legally possible. Who knows? But no decision on that has yet been taken. But I'm an optimist, like I say. European Union Trademark Directive. My understanding is that it's expected that this will be implemented. It will be transposed into UK law. Because, like I say, the transposition date, I think, is January of 2019. In other words, before, technically, we leave. And so work is being done to bring that across. So the expectation at the moment is that whatever happens at the point we leave, our law is likely to be aligned with the European system. What happens after that, of course, depends on the arrangements put in place. Either they will continue to be aligned or they may diverge. We also know that, generally speaking, users seem to like the EU IP system. And we're not picky. And there are bound to be some people who don't like it. There are some people who have deep-seated views about, for example, non-use and so on, and whether use in one part of the EU can support a mark in another. There are issues around that. But generally speaking, the feeling that this particular point is not a UKIPO point. It's more a point that we as CITMA have picked up, is that people like it. It's good for business. It gets you rights at a reasonable price, which are capable of enforcement across a wide range of countries. And generally speaking, they like it. What don't we know? It's a much bigger list, isn't it? Much more closely typed. We don't yet know what sort of Brexit it's going to be. Now, to add to this little list here of hard, soft or grey, this week we had a red, white and blue Brexit. Now, I must confess, I don't know what a red, white and blue Brexit is. And I think I'll have to wait and see exactly how that translates out. Essentially, and different people put different interpretations on these things, but my understanding is hard means we just walk away, straight division, that's it, everything stops on day X, and we start from scratch with new WTO rules or whatever. Soft means there's some sort of transition, some sort of continuing relationship. Grey, as I understand it, means that there may continue to be a closer relationship than people might otherwise have thought. For example, it has been suggested in the last week or so that the UK might pay in money to the European Union for certain bits of the system. Who knows? There are, as I'm sure you can imagine, a lot of political voices being raised for and against these various options. Different people have different and very, very strongly held views. So it's far too early to say what form it will take, and a lot will depend on the attitude of the negotiators when they actually get in the room. Whether they're going to be hard or soft negotiators, whether they want to compromise or not, what their political drivers are. How far does economics feature in it? How far does sending a message to other countries feature in it? And so on. We just don't know. We don't know what sort of transitional arrangements there could be. I think we all expect there will be some, at least as regards intellectual property. Difficult to see how you couldn't have it without causing absolute chaos. We don't know what will happen to existing rights, EU trademarks and designs. There are other areas too. It's not just about trademarks and designs. So supplementary protection certificates, how will they be affected? Cross-border copyright. The European Union has a number of relevant directives in that respect. For example, the InfoSoc directive. Bear in mind that, for example, satellite broadcasts are cross-border. You have a harmonised system within Europe. How is that going to be affected after we leave? Exhaustion of rights is turning out to be quite a hot topic. Didn't think it was going to at the start, but it's developing slowly into something that really could be quite a heated debate. At the moment, of course, first marketing with authority in the European Union exhausts your rights. That's fine, we understand that. There's no international exhaustion of rights. So something coming in from outside the European Union can be stopped at the border unless consent can be irrevocably proven. And I say my first thought was, well, what will change? What's the problem? Other than, our border will shrink to being the UK, it'll just be the same principle but applied to UK. But it turns out if you dig back into UK law, particularly passing off our unregistered trademark regime, that there was international exhaustion of rights. First marketing abroad effectively exhausted your rights. And there were a couple of cases going back to marketing in the US, for example, marketing of razor blades in the US. And the court said, once you put it on the market, that's it. Unless there's some legal reason why it should be prevented from coming into the UK. It's completely different to the position you have in the European Union. In fact, the case I'm thinking of about razor blades, I think the goods were prevented from coming in because it was about quality. The reason why they couldn't come in was they were being passed off as the same quality goods when it turns out that, for whatever reason, people in America would tolerate far worse razor blades than people in the United Kingdom. So they were stopped from coming in. There is a lot of work being done on this particular issue at the moment, and we'll have to wait and see where that one's going to go. Obviously, there are business interests on both sides of the coin. Parallel importers will want to be able to bring their goods in, and businesses based in the UK will want to stop that if they possibly can, I'm sure. So a big debate to be had there. Cross-border enforcement. Wonderful system at the moment. You can get an injunction pan-European on a trademark case. How will that pan out in the future? UPC, I've already mentioned. Protected designations of origin. Don't know what's going to happen with those. Or with geographical indications. Will we import them into UK law or not? Rights of representation. And that's tied up to some extent with the wider question of what happens to British lawyers who are already established and practicing through offices in the European Union. Will they continue to have a right of establishment? All these things are intertwined. So, as at the point of the vote, at the risk of stating the obvious, there has been no immediate loss of protection for European Union trademarks in the UK. It's the same for community designs. There are over 1 million registered European Union trademarks. Whatever this process entails, it's going to involve operational challenges for everybody. Whether it's finding some way to get all the rights transferred into UK law, whether it is filing forms to notify registries of your interest in various countries, or whatever it is, there's going to be a huge administrative task involved. Think about the possibilities of re-examination, challenging rights at a local level, the number of possible oppositions and objections that might arise. Just think about how you're going to police it within your offices in terms of dealing with your clients and giving them the right advice and dealing with the record-keeping issues and so on. Now, CITMA, it says ITMA there because we didn't update the slide, but it's got CITMA at the bottom, has investigated this and has come up with a number of possible scenarios for the transition process. And to a large extent, this is based on what other people have done in the past faced with the same situation. And it turns out there are about 7 possibilities. The scenario we favour, as I said before, is to keep us closely to what we have. Thereby, we think that will minimise cost, will minimise the resource burden on firms and on businesses. Businesses, your clients, most important people, whilst at the same time maximising legal certainty. So, this is where we get into nice coloured charts. A quick word about colour coding. As you might expect, green is good. Amber and brown are not so good, but okay. And red is bad. We don't like red. It's bad for us, for business, for everybody, we think. And we've shared this model with UKIPO and with government, and it is widely being referred to as a list of possible options. So, let's start at the top. EU Plus. I'm told that I should be referring to that as UK Plus, but I didn't prepare the slides and it hasn't been updated, so it doesn't really matter. What is that? That is, I think, the one that we tend to most favour. I think recognising that it's not possible to keep the EU system that we have at present because of the very nature of Brexit. It's possible to envisage a system where, with a little bit of judicial treaty and regulation tweaking, you have a system whereby countries which are not members of the European Union, or indeed the European Economic Area, can nevertheless contract in to the community trademark and design system. So that, in effect, they accept the application of that system and the application of those rights in their country, even though they're not EU members. Now, that wouldn't just serve the interests of the UK, but it would also be a useful device for potentially candidate countries in the future. It would give them an opportunity to sample how EU institutions work and to start to converge aspects of their economy into the EU system. There are potential advantages. And not least because, in effect, nothing would really change at ground level. The register, the European Union register would continue to apply, for example, to the UK in this system. It's just we wouldn't be part of the European Union anymore. We would have accepted the extension of the rights into the UK. Politically, that is undoubtedly a big ask. It would require a rethink of the fundamentals of the European Union trademark regulation and indeed the system under which the whole scheme of the European Union operates. And as I said earlier, if the problem for the UK is that it will not allow in the future decisions of the CJEU to run in the UK, clearly this can't work. You'd have to find some other method of reaching decisions. One that occurs to me would be the European Free Trade Area Court, the equivalent. But I suspect that problems like that are the sort of thing that will actually make this particular solution unworkable. But never say never. It's certainly one we've put forward as an institute, and we hope it'll get appropriate consideration. Jersey, the Jersey system. Jersey is not part of the European Union. Nevertheless, it treats European Union trademarks as if they apply in Jersey. It recognises them. It isn't reciprocal. This isn't, you won't be able to take into account a Jersey registration to invalidate a European Union trademark, but Jersey will take European Union trademarks into account. Now, as you can see, we've got a big red box at the end of that, in a section marked legal certainty, saying we think that creates a high degree of legal uncertainty. Whereas, I didn't mention it before, but you can see on the top line, we've got greens across the board for our UK Plus option, which more or less speaks for itself. We say that's the best one of the lot. The advantage of Jersey is that there's no real cost to business. It's just a deeming procedure. You just assume that the rights continue to apply within the United Kingdom. And it doesn't require any UKIPO resource either. There's no cost to them. The next one we looked at was something based on the Montenegrin system when they were faced with a similar situation. And that's simply to effectively just import all the European Union rights onto the UK register. 1 million of them. Someone's going to have to do an awful lot of computer programming to make that work. And we're all going to spend a lot of time reading journals to make sure we pick up any conflicts. It's suggested that that might occur automatically at the end of the consultation period when we actually leave the European Union, or there might be some sort of window for that to occur, a window of opportunity. It does create a degree of legal certainty because the rights are then on the UK register. could be costly to business and would require a pretty big resource from UKIPO. And there are likely to be a reasonable number of conflicts once those rights have been imported, because UK trademark owners will probably want to challenge them in a way that they may not have done at community level. The next one we came up with was Tuvalu. It's nice how we're bringing the names of these rather smaller countries to the fore in this, particularly Tuvalu. They don't get mentioned very often in trademarks, so it's nice that we've got them there. They had a system which we could emulate, which was optional. But essentially the system would say that you have a period of time as a trademark owner, as a European Union trademark owner, to exercise an option to bring your rights onto the UK register. And there's a row of browns there, as you can see, but it does give you some high legal certainty. There will be cost, because obviously exercising an option is something that requires work. There'll be cost to business. There'll be cost to UKIPO, because they'll have to have staff to do it. And there's a high possibility there'll be post-grant conflicts. How long would the period be? Who knows? Veto describes something very similar to Tuvalu, and indeed to Montenegro. But UKIPO might have the option to veto the import of any specific right for a range of reasons. So typical reasons might be that the mark had already been examined in the UK, the same mark, same goods, and rejected. So we wouldn't allow that mark to be imported. Something like that, some sort of substantive reason why it wasn't appropriate to simply import the mark and that it really should be filed as a refiling in the UK. Ireland. This is quite an interesting one. This envisages that fundamentally you wouldn't have to think about what you did with your European Union trademark in the context of the UK IPO, the UK register, until there was a change of some sort of status relating to the European Union trademark. And the obvious change of status is renewal. Comes up at renewal. At that point, you've got to think about whether you keep the mark anyway, so it would be appropriate to think about whether or not you want that mark to be converted or transferred into the UK system. Until that point, first renewal following Brexit, it would continue to have effect in the UK as a community trademark, European Union trademark, in the way it always had. After that point, if you haven't elected to transfer it over, it ceases to have effect. It could also be on assignment or change of representative, whatever, that you could pick any particular triggering event for it. Renewal has a certain attraction to it because we know that community trademarks are not going to last more than 10 years. So there's an end point in sight. And then, of course, there's the option, you could argue there's already an option in the European Union trademark regulation, conversion. It has some attractions, not least because it involves re-examination. There is an argument against just importing all these rights and leaving it to business to have to fight the examination battle. After all, in all other systems, within this universe, as it were, of European trademarks, examination is carried out ab initio by the examining authority. And the workload that would impose on everybody, potentially, is huge, particularly at Brexit Day, because everyone will be getting their applications for conversion ready the night before. And, of course, for the owners of the rights, they'd be facing the whole thing going through the re-examination process and potentially being opposed all over again. So quite a lot of legal uncertainty, quite a lot of cost involved there. But what you do know is once the mark's gone through the process and got on the register, it's as rock solid as it can be. So good legal certainty, poor legal certainty potentially at the point of application, but good for post-division conflicts. So a range of possible options there, and it is impossible to say at this time which will be pursued, because it will probably be decided in the context of many other wider discussion points, for example, financial services, general trade arrangements, and so on, without focusing purely on IP. One of the problems in this debate is that sometimes trademarks are perceived as being of any marginal relevance But like I say, there are a million community European Union trademarks. Businesses within the European Union and throughout the world have flocked to it as a successful system. And I think it's one of the single most successful pieces of harmonised legislation that the European Union has brought forward. And if you look at it in that light, it really ought to be seen as being more important than it possibly is being seen at the moment. But these are issues for our political masters. How am I doing for time, Ruta? Fine, excellent, that's good. Yeah. So, transition issues. What are we looking at? Seniority could be a bit of a problem. What do we do about it? Do we just, if the marks are coming onto the UK register, do we just choose to forget that? It's too complicated. Let's forget them altogether, forget seniority claims. Do we restore? Obviously, we can only take into account seniorities based on UK marks. Do we restore the previous mark, bring it back to life? Do we just recognise the existing seniority claim? Do we ignore it altogether? There's a possibility, therefore, of having two marks on the register. Non-use. Currently, if you convert a mark from the European Union system, you get a brand new non-use grace period. And certainly until recently, that was a nice little trick you could use if you were under attack at EUIPO. You simply pulled the mark out of the system, converted it over, and made it invulnerable yet again. Now, unfortunately, EUIPO has now stopped people from doing that, which is a shame, because it was a great little wheeze at the time. But do you have a new grace period? Or alternatively, do you say, no, you get the grace period you had when you filed your originating European Union trademark? Should there be a shorter period? Should you say, okay, well, you do get a new non-use grace period, because you could, of course, opt to convert, but it's only for 2 years? What if the mark that's been transferred over as a European Community trademark prior to Brexit could have been supported on genuine use made in countries outside the United Kingdom, but had been put to no use in the United Kingdom? Would it be right to have it vulnerable to cancellation from day one on the grounds of non-use? Or would you be entitled to rely on the use you'd made elsewhere in the European Union? Re-examination, third-party objections. There is, I think, a really quite fundamental question as to whether or not you should re-examine. I suspect the debate is going in the direction of no re-examination, but fundamentally it is the case that just because a mark got through the European Union system doesn't mean that mark would be acceptable in the United Kingdom. And doesn't that mean that United Kingdom businesses would be prejudiced by that lack of examination and thereby having to effectively assume the burden themselves of challenging the mark? Relative rights as well. How do you deal with those? Similar sort of problem. The next issue is one that's really sort of peculiar to the UK. That's intention to use. As I'm sure you all know, that it is a requirement to state that you have an intention to use a mark in the UK at the point of filing. That intention does not exist in the community trademark system. So what would we do? Would we deem that marks that were transferred over had the requisite intention to use? Would we require marks coming over to be accompanied by a declaration that there was an intention to use them? Would you declare at the point of application, or would you declare at some later point? Would you have a window for doing so? Priority periods, there might be an issue there around priorities and re-examination of priorities, because a lot of the time, of course, the priority dates will be long gone. And if you're not submitting to re-examination, not going through a conversion process, there's an argument to say you shouldn't get the benefit of priority either. The language one might turn out to be, operationally, really quite a difficult one, because it is undeniably the case that there's going to be a lot of translation work involved, and there might be all sorts of problems arising from that, not least because of the haste with which it's being done, the sheer volume of work. So there's got to be a process for dealing with those sorts of issues. I think the UKIPO has already seen a significant increase in UK filings because naturally a lot of people are saying insure yourself against the uncertainty by filing both. File an EUTM, file a UKTM as well. You'll get the UK more quickly possibly. But at the end of the day, someone's got to pick up the bill for dealing with all of that. And you've got to have the staff in place to deal with it. Not just in UKIPO, but in representatives' offices as well. So there could be a spike in work, and somehow that's got to be managed and dealt with. Could also be a spike in contentious work, opposition proceedings, cancellation proceedings, particularly if rights are imported wholesale. It is likely that there will be a high level of challenge in the first 10 years or so thereafter as people try to rebalance their rights. Things that they weren't concerned about at a national level, at a community level, they are concerned about at a national level. If you've got a court case on relating to a European Union trademark in, say, the Intellectual Property Enterprise Court in the UK, what happens if it spans Brexit? How are we going to deal with that? About the fact that up until 30th of March 2019, it's an infringement. On the 1st of April, it isn't. Going forward in the future, will we look to decisions of the CJEU, for example, as being persuasive, even if they're not binding? Practice of EUIPO, will it be persuasive if not binding? Or will we go back to paddling our own canoe, as we say in England, diverging from the path of the European Union? And pragmatically, you've got to think about the impact on all those coexistence agreements that you've already signed. There's an awful lot of them, and they didn't envisage anyone leaving the European Union. Now, that's quite a big due diligence process, and at some point, it's going to end up in court. Someone is bound to have an agreement that they say no longer applies in the United Kingdom or is otherwise affected by Brexit. Court orders against infringement, particularly cross-border ones. Again, how do we deal with those? Do we have to go back to court and get them remade, as it were? Do we have to go back and have sections taken out of it and go to court again in, say, France or Germany to have equivalent orders put in place? So it's not just a case of bring all the marks in and take it from there. There are actually an awful lot of interrelated and complex questions, and probably far more than we put down here when you start to get into the overall jurisprudence. Designs. I'm not going to go through this slide unless anybody particularly wants me to, because in effect it is the same as the slide on trademarks. The options are pretty much the same. And life is too short to just repeat it all again. So we'll talk now, that covers off registered rights, and really, like I say, all you can say is nobody knows, and there are lots of options and many, many complex issues to consider. Rights of representation. At the present time, nothing has changed. As I said at the outset, UK attorneys can still act before EUIPO. UK lawyers, and interestingly enough, registered trademark attorneys are not considered by CJEU to be lawyers, even though we can appear in court and can do all the things that other lawyers can do, not currently recognised to appear before the CJEU. It's something we were working on prior to Brexit. We'll have to see what happens going forward. But at the moment, everything's the same as it was. It is a key CITMA objective to ensure the continuance of rights for UK trademark attorneys to act before EUIPO. Why should a party be required by treaty change to change his representation when he's made a valid and sensible choice to appoint a particular attorney? And as I say, there are wider issues regarding how the legal profession and the European Union and the countries of the European Union and the various different professional bodies and regulatory regimes will intertwine post-Brexit. It's not just about UK attorneys. Will UK lawyers be able to set up in Europe? Will they be able to have freedom of establishment of practice? Will they be able to appear before the CJEU? But I keep making this point. Currently, it is business as usual. Actually, I'm just going to very, very quickly go back to designs just for 1 second to make one point which I omitted to make, and it's this. It is about unregistered community designs. The UK, of course, as I'm sure most of you know, has its own sui generis system of protection for unregistered designs, unregistered design right it's called, and it is not a straight lift from the unregistered community design system. There is no equivalent to the UCD system in British law. That means you can't just grab European law, you can't just grab the unregistered right from the European system and say it's deemed to carry on in UK law, because there's nothing to hang it on. We would have to have a substantial rewrite of law to actually import that system. So we don't quite know what's going to happen there and how that's going to be taken into account. So I just wanted to make that's a specific point on designs. So yeah, CITMA is going to continue to work closely with all stakeholders, particularly with government and the IP offices. So we're in constant contact with UKIPO, and we've spoken to other offices too, including EUIPO. They're not in a position to tell us what's happening yet, but we're hoping to hear sooner rather than later what their thoughts would be, but obviously no timetable. We're certainly continuing to talk to our fellow international organisations, and I'm sure we're looking forward to hearing what ECTA's views on this are likely to be. And we're very keen to hear everybody's views. And if anybody has any views on what it should look like, drop us a line. There's an email address. Oh, I need to move on one slide. There's an email address there, which you can drop your comments to. So, I'd just like to say, Paldies par Uzmanibo. I think we've got it right. Thank you very much, and happy to take questions. Thank you.
Thank you very much, Philip. I guess we have a good overview again about this very hot topic. And as we all know that, as you mentioned in the beginning, actually no one knows what we can expect and probably even don't know when, because also March is just mentioning a date, but it doesn't mean that it will, yes, it doesn't mean anything. So now I will open the floor for the question, and as a first one, I would like to give a floor to Mel Kenny, who is a prorector of this nice university which hosts us today. Maybe you have any comments, because I know that you are commenting on Brexit issues quite often, and yes, yes.
I mean, perhaps.
Yeah, I think there is a mic. Or
perhaps. Oh.
Okay. Yes.
Right. Well, I think I'd just like to repeat what Philip has been saying about we just don't know, and I think that's part of the problem, isn't it? That it is we are taking a leap into the dark.
Somebody said we're walking around in the dark room trying to come up with a plan to find a black cat that isn't there.
Right. And some would say that's an optimistic assessment. I think that is a great problem. I think there is increasing realisation that it's likely to be some form of hard Brexit rather than the softer Brexit that some have been predicting. I think I am very concerned when I hear that the UK government now has divided the work into, I think, 750 work streams that are contributing to the Brexit solution. The extent to which that can be easily delivered, I shudder to think really what of that dynamic. Perhaps it's also interesting to think about the the kind of institutional arrangements that we might be able to anticipate if we're, and this is again where the UK government talks about this bespoke arrangement, that it's not necessarily the Swiss model, it's not necessarily the Norwegian model, that it's something that's unique, which of course makes our job even more difficult because we can't conveniently say, well, there will be that common institutional framework. I think that was something from a Swiss perspective that was always something that was very complex in the bilateral context, that the lack of that institutional structure meant that there was, for Swiss firms, legal uncertainty. And what the Swiss firms ended up doing is, of course, they went to London for their legal advice. I mean, this is another perverse development, that those firms are now probably going to Dublin or to Paris. They're looking at for their legal advice in other centres. So really, I mean, I think that really amplifies the point that you were making about also these representational, these rights to represent clients, which are quite contentious. So we really are making a leap into the dark. We're not sure about, we are moving towards leaving the EU, but being uncertain about that pattern that we can establish after Brexit. So I think that is the great dilemma and the great challenge.
I think I'd absolutely agree, and it's not for me to get into the politics of it because it's a very heated and emotive area, certainly in the United Kingdom, I'm sure you picked up. But it is one of those situations where, as far as the negotiation goes, no one can really make any predictions until we know what the overall negotiating stance of either side is. And at the moment we have, the British approach seems to be that they must negotiate in simple terms, as Boris Johnson has rather trivially put it, because they want to sell us Prosecco or BMWs or whatever it is. And at the same time, the message from the European Union, understandably, is no, you don't get it. It's not as simple as that. We have political drivers that require us to take a hard view on this. Now, until we see the real politic involved, it's very hard to come up with any real conclusion about what that will translate into.
Mm-hmm. I mean, I don't want to encourage you to get into too sensitive an area, but it also seems that we are getting mixed messages from the different governmental departments, the trade department, the office for exiting, the EU.
I would think that the best way to find out about that is to read the Daily Telegraph, actually. But I think it's also true that there are mixed messages coming from within the European Union as well. I think across the board politically, there's a lot of juggling for position. We've seen just in the last week or so hints of positioning starting to come out publicly. Now, I'm not going to even begin to try and read the tea leaves on that one. I think we just have to wait and see how it starts to pan out. And I think we'll all know more, hopefully we'll all know more by this time next year.
Okay, thank you very much for your intervention. Now coming back maybe to the more easier way, it's trademarks, I think.
Let's keep it trademarks.
Yes, let's keep it quiet. Maybe someone else has any questions, comments, please feel free to use a microphone. Yeah? Please state your name and company.
Yeah, for sure. So my name is Alena Sevtsova, agency TriRabbit. I have quite a practical question to Mr. Philip Harris. Let's imagine I'm your client. What will be the best advice from you if I want to file a European trademark right now? What should I do to file EUTM and to duplicate it with a British trademark, or should I still stick to EUTM to be on the safe side?
I must say, my view and the advice I have given when I've been asked, although I don't do applications anymore because I'm a barrister now, but when I've been asked about this, it has always been, in this situation, file both.
Okay.
Straightforward and simple as that. So
whatever the scenario applies.
Bearing in mind that the cost of filing UK is very low anyway, it makes sense for the purpose of certainty to basically insulate yourself now against the possible consequences of which you know nothing at this time. So.
Okay, thank you.
Okay, great. Any other questions? Max? No?
Well, perhaps I could fire one off to the audience then.
Someone else?
Well, while we're waiting for someone, for all the hundreds of questions that are bound to flood in just a moment,
No? Okay.
we put in to our presentation, as you saw, a list of possible options for what happens after Brexit Day, whenever that is. Let's get a feel around the room. How many people like, for example, the Montenegro option where everything is just automatically put onto the UK register? How many people like that one? Hands up, don't be shy. Nobody. I'll take that as a no then. Anyone? Anyone want to speak in favour of it?
I think there are so many uncertainties in
There
this.
are.
Of course, we are on the position that actually all Baltic states exiting Soviet Union, and so we were in the position that all these rights were somehow transformed into national ones. But that was a little bit different historical moment, so, and we create a separate country now, and we were quite small countries, so therefore I think we were on the little bit different circumstances. But still, yeah, I think there is so many uncertainties that no one will be so brave to...
How about the other end of the scale, where we have some sort of UK plus or EU plus, where effectively we stay a contracting party to the EU, but we're not the EU to the European Union trademark system, but are not part of the EU. So the community trademarks continue to run riot in the UK.
That's I think it's very difficult to answer, because it's there is different angles from which you are looking on these issues. If you're looking from the perspective of trademark owners, there will be one side and one argument. If you're looking from the perspective of the practitioners, they will be completely different view, because it's different issues and different angles, and of course it will give it, as you know, in the court, you can...
Yeah, and of course, if you're looking at it from the context of a politician or a civil servant, there are a whole different set of drivers involved.
Yes,
so,
exactly.
That sort of illustrates how difficult all these
It is
questions are. And in many ways, it could be a very fun time to be a trademark attorney.
Oh, that's true. Forward. Yes, that's true. Does anyone has any comments? Sozos? Yes. Please state your name as well, because I know you that probably.
Sozos Yadulu from Cyprus, ECTA First Vice President. Actually, I think it's inevitable to go a little bit into politics again. I mean, there has been some statements saying that until now the UK was an EU member with one foot outside the EU. So with all your proposals, I have the impressions that now the UK wants to be outside the EU with one foot inside. So wouldn't that in the end be a little bit similar? And then the question is, what is the motivation? And this would probably help you to enlarge a little bit and show the advantages of it. What would be the motivation for the European Union to accept any kind of continuation, instead of saying clear cut, you know, you're out, so your team rights are out too? I know I'm being provocative, but I want to have your answer. Thank you.
I sort of think that answer is probably above my pay grade, as they say. And I do hesitate to get involved in the politics of it. I can only really say, I can put this only in the context of trademarks. The other issues, I accept there's a whole political debate around whether we're one foot in, one foot out, and so on. We're not looking at it from that perspective. We're looking at it from the perspective of purely what we think is best for the IP regime and for the people who are within that regime, the clients primarily. And there doesn't seem to be a lot of debate that what we have is pretty good. Now, politically, I completely accept that what we think might be possible is not doable, because there are other overarching considerations. We're not looking at it from that point of view, we're looking at it from the point of view of what practically is the best way forward. And so those other questions are really not for us to answer. Those are much more almost philosophical questions about the position of the UK and the EU between themselves. I understand what you mean when you say what's in it for the European Union. One could come up with all sorts of reasons why they might want to go down a particular road. For example, harmonisation has, as far as I can see, proved to be very beneficial for all concerned. But when you put that against the overall political objectives involved, I don't know to what extent that would have any currency. We'll have to wait and see. Just don't know.
Okay, thank you very much. We are coming to the end of the second workshop, so we will have to stop it immediately because our stream will stop immediately, so we can continue these discussions afterwards. But on behalf of ECTA, I would like to thank you very much for having for coming to Riga and share your view and experience with us today. Thank you very much. I also would like to thank Riga Graduate School of Law who host us today, and thank you, Mel, you personally, because it was very nice to have you and get your comments also on this topic. Thank you very much, and hope to see you on next workshops somewhere in Europe. Thank you. But we can continue the questions if any of you have them unofficially after this workshop. Thank you very much.